Go ahead and rest. Okay, thank you.
Thank you, counsel. All right, the next case on the docket is Baldwin versus Kirchner, but I think it'll be more convenient to take Shaw versus the Department of Business Regulation, or the Shaw versus Department of Business Regulation here. Are the lawyers here?
Yes, Your Honor.
All right, in that case, we'll go ahead and with that case.
Good afternoon, and may it please the Court. My name is Bradford Bailey, Fort Lauderdale, Florida, and I represent the appellant John Shaw. We're here today on an appeal from a ruling by the Department of Business and Professional Regulation, Division of Pari-Mutuel Wagering, finding that Mr. Shaw had 3 drug positives in connection with 3 different racehorses. Before I get into my argument, Justice Griffin, could I please reserve 4 minutes for my
I'll try and help you.
rebuttal? I'll try to make the facts brief, and we have a very, very narrow issue in our appeal. Mr. Shaw raced 3 horses as well as other horses called a racetrack down in, it's actually Miami, Florida, right on the border over there. The state detention barn is responsible for collecting samples of blood and urine, and we'll get into that during the argument. The samples then find their way up to the University of Florida under a contract between the racetrack, the state, and the university, and the university comes back with a drug positive. The amounts really are irrelevant because we have 0 tolerance in horse racing, but they come back finding 2.8 nanograms or 2.8 billionths of a gram per milliliter of urine in one horse, 2.8 in another horse, and I think it's 5.7 in the third horse. At the time the report comes back from the University of Florida, no one at the Division of Pari-Mutuel Wagering knows what horse it is. And then the process starts of confirming the identity of the horse that it's alleged that the urine came from. And that's really what this appeal is about, that process. Ultimately, the division determined through its division investigator, the only party that testified at the trial from the division, that these 3 racehorses that tested positive for this particular derivative of fentanyl were these 3 horses of Mr. Shaw's. The issue on appeal, or the issues on appeal, is whether or not this sole witness that testified for the state could present the predicate evidentiary-wise for either the documents identifying the horse, the logs for the security, and the 3 sets of documents, which I'll get into, that were used to correlate or supposedly correlate to establish that the urine that was tested positive at the University of Florida was actually the urine from the 3 horses. Just to be clear, we concede that the urine that was tested was positive, and that there were 3 positives of urine at the University of Florida. That's not a disputed issue for this court. What we contest is that the urine came from the Shaw horses, and that the methodology that the state used, as well as the quality and quantity of the evidence that they used, failed to meet any exception and failed to establish that the urine came from the Shaw horses.
And that as an alternative theory, 3 other horses on 3 separate days must have had this in their system, and all 3 of those got mixed up with your client's horses?
No, Your Honor. In fact, there's no testimony in the record whatsoever as to how many fentanyl positives there are or were at Calder Racecourse over the positive period of time was, I believe it was May 2008 through November 2008, and there's no testimony in the record whatsoever whether there were 50, 100, or just these 3. So if you're asking me, is that just coincidental? I couldn't tell you. I can only tell you there's no testimony in the record that there's any more or less. If Your Honor would recall that the way this arrived for what was basically an expedited proceeding is that there is a statute that provides that the director of the Division of Parimutuel Wagering can automatically suspend a licensee's license, basically ex parte, under certain statutory findings. And the only remedy available to the licensee at that point is to say, is the paperwork proper? In other words, did the director of the division look at the proper paperwork to make a determination that Mr. Shaw could be a danger and he issues an ex parte suspension? Now, our choice at that point in time is to either fight the ex parte suspension or consolidate it with the administrative complaint that's filed shortly thereafter, which was the decision that we made. So he was suspended for 6 or 7 months prior to the ultimate resolution of the ruling, and ultimately a stay by this court for the final 5 months. But what basically transpired then was a consolidated hearing before the administrative law judge, not really dealing with the summary suspension, but just dealing with the evidentiary basis for the conclusion that the urine came from the Shaw horses.
Isn't the bottom line your primary argument that the documents did not properly come into evidence?
Yes.
And that was because, and I don't know if I know how to pronounce her name,
Diana Neera,
qualified, or the appropriate person to introduce them as a business record exception?
Right, and it's both sides of the exception, and I want to highlight that because there's not a lot of cases on the second side.
Well, basically, your argument was that she wasn't qualified because she really wasn't there. She didn't run the day-to-day operations and collecting the samples and having them tested. Is that basically right?
Correct.
Well, is that really necessary in order for a person to lay a predicate to be qualified to get business records in, or is it that they know how the business records are kept in the normal course of business?
There are 2 cases from the First District that I think deal with that. And the case I'm relying on is the Johnson case. It's cited in our brief. It's at 546 Southern 2nd, 741. And it's another administrative law case. And what they basically say is the witness that's going to act as the records custodian, if you will, although she admits she's not the records custodian, or in this case, the qualifying witness, has to work in the same business as the business she's testifying about the records of.
Well, she testified in detail that she knew about the record keeping, how all these records were kept, and the trial court said that was a sufficient foundation. Right?
And Johnson says it's not, and I would point out that her job, she's an investigator. That's her job. She comes in after the fact, and she does not work at the state detention barn, which is what I say the business records are that I'm seeking to exclude, or was seeking to exclude both at the trial level and at this court. She is on the investigatory side. She comes in after the fact and puts together a folder of documents. She does not work. I can tell you all the things that she doesn't do.
Well, our standard of review is abuse of discretion, isn't it?
Yes.
Did the trial court abuse its discretion in holding that she was qualified because there was a predicate laid that she was very familiar with how the records were kept in the day-to-day business?
Yes, for 2 reasons. One, she doesn't work in that business, and that's a legal standard by that Johnson case. If you distinguish her from being an investigator from working in the detention barn, all she's saying is, I know what all these different people do, from the person that collects the urine, from the veterinarian that pulls the blood, from the person that fills out the log from the detention barn, from the person that fills out the log of the blood in the urine as it's packed, from the person that sends it to the state of Florida, the University of Florida lab. But I have no personal knowledge of any of that having to do with this case. It's not part of my job function. It's never been part of my job function. I don't work in any of those areas. I just know what's supposed to be done by virtue of a manual I have here that I haven't they don't even introduce into evidence. So under Johnson, because she doesn't work in that business, there's a legal distinction for abuse of discretion. The part that I tried to answer earlier, Judge Sawaya, if I'm pronouncing that correctly, is that both the public records exception and the business records exception have that one sentence or sub-sentence at the tail that basically say that business records will come in or public records will come in, quote, unless the sources of information or other circumstances show lack of trustworthiness. And that is my biggest argument in terms of the abuse of discretion and failure to meet the predicate. And again, I'll cite you both the Johnson case for that proposition and the Juiced case that's also cited on our brief, which are the only two cases that I have found where a court has actually ruled that the evidence itself lacks sufficient trustworthiness to be admissible pursuant to the requirements of the rule. So I want to take it beyond, is she qualified?
Well, why isn't the rule really whether those that collected the information that go into the record act in the in the scope of the business and are familiar with how that information is accumulated and put into the record, as opposed to the custodian that comes in and says, well, I know how the records are kept. These are the records that are kept in the normal course of business. I know all of that, and here are the records.
Yes,
so
sir.
You make it sound as if the person, the custodian of the records that comes in to testify, to put the business records in, has to be the one that actually accumulated the information and actually put the information into the record and works in that area.
I'm not trying to make it sound that way. I'm saying that the Johnson case specifically says they need to be in the same business, and I'm trying to highlight the distinction.
You're saying that she's not in that business.
The business of operation of the detention barn.
All right.
And she goes through who all those supervisors are and all the way up the chain. Now, I'd like to highlight, it's interesting because the same person that's supposedly the qualifying agent of the evidence is testifying it's all wrong. Now, I know my opposition has said that I'm nitpicking and grasping at straws if I got the quotes correctly. But if Your Honors have reviewed the exhibits, because this is just an exhibit-intensive case, that it's basically 9 documents that come in, and there are 3 sets of 3, for lack of a better term, for each horse. We stipulated that the horse ran in the race. That's actually the 4th one for each horse. There is a security barn log for each horse, which is exhibits 2, 7, and 12. There's a sample collection tag log, which is exhibits 3, 8, and 13. And there's a sample collection log, which is exhibit 4, 9, and 14. And what you're supposed to do, apparently, from their testimony, is you take exhibits 1 through 4, you take exhibits 6 through 10, you take exhibits 11 through 14, and somehow you draw the conclusion that blood and that urine, and actually they exclude the blood, that urine came from those horses. The very witness that you're asking me is the knowledgeable person, is testifying on cross-examination, and this highlights my point that it's inherently untrustworthy, to the following, and I'll give you the page references.
Where does the inherently trustworthy argument come into play?
If it's not inherently trustworthy, then it doesn't come in under either exception of the hearsay rule. Therefore, there's no direct evidence, because hearsay can be used to supplement, but you need direct evidence.
Are these documents public records or just business records?
Well,
As in public records, there's a specific trustworthiness.
no, if you look, Your Honor, and there's one of the cases I have specifically says, in the public record exception, it has that same language. In subsection, I think that's 08 versus 06, which is the business one. The public records come in unless they're inherently untrustworthy.
Is this a public record? Are these public records?
Well, I don't want to stipulate that they are, because they don't have a qualifying witness, as I've already expressed to Judge Sawaya. But if they are, and supposedly the reason they're public records is we don't want to have these public officials or public employees come to court unnecessarily, and they're inherently reliable because they have no reason to be false, they have no reason to not report accurate things, they have no stake in the outcome, and there are all of these reasons. And yet, we're talking about veterinary assistance, which is a very loose term, for an employee who is described as a job that catches urine from either a male or a female horse when the horse is in the test barn in a container, supposedly packages that container, and supposedly puts...
But the groom of the horse is there representing the horse and the horse owner, right? I mean, they're there during the collection process and all of that. I mean, and that happened in this case too, didn't it?
The grooms are always there.
Right.
Okay, and
to make sure that it's trustworthy, right?
No, Your Honor, that's not why they're there.
Why are they there?
They're there because it's required to have a state license to come into the detention barn. There is nothing. If Your Honor looks at the cards...
They're there to make sure that, I mean, and I'm not going to interrupt you again, but they're there to make sure, as a representative of the horse and the horse owner, isn't that what the groom is there for? To make sure that, you know, that their horse gets the proper test, and that the test for that horse is matched with that horse's name, and that everything is done properly? Or they're there for some other reason? What other reason?
Your Honor, it takes a state licensee to escort the horse after the race into the security barn enclosure or the test barn enclosure. And again, I don't want to... The statute says, or the rule, excuse me, the rule of the department says that the owner can have a witness there, the trainer can have a witness there, and a process should be followed. However, if you look at the card itself, the tags, and those are...
Well, in this case, was the groom there representing the owner and the owner of the horse?
In this case, there was an assistant trainer that was present at one test, and there was two grooms.
Well, I call him a groom. I don't know, groom, assistant trainer. There was somebody there on behalf of the horse and the horse owner, right?
It's actually somebody there on behalf of the horse and the horse trainer.
Okay.
The statute says an owner can have an option to have somebody there, the trainer can have an option.
And the purpose for that person to be there was to escort the horse?
We can assume, yes, as Diana Nera testified, it needs a state licensee to come into the detention barn. And Your Honor, I don't know if I want to answer your questions, and I don't know if this 4 minutes that I have left is also my rebuttal time.
Go ahead.
I'm happy to go into it really quickly for you. There's nothing in the form, if you look at those exhibits, which are 3, 8, and 13, that says when the groom signs or the trainer signs, quote unquote, I am affirming by signing this tag that portions may or may be attached to the urine or blood, but I am affirming that every process that was supposed to be followed was followed. I'm going to use up my time because I want to point out all the deficiencies in the logs which make them inherently untrustworthy.
I just have one other question.
Yes, Your
There is
Honor.
some case law that says unless you file written exceptions that you waive your right to appeal. Is that, you want to address that real quickly?
Yes, Your Honor. I think these are questions of law and not questions of fact. I know we cited 90.105 for preliminary questions, that the questions of law are the admissibility of evidence for the court and not an exception as a question of fact for the director of the Division of Parimutuel Wagering. I guess in the future, if this court were to rule that way, then we will know to always take an exception to everything, but we believe that to be a question of law, not a question of fact.
Did you argue below that you didn't have to file exceptions because they were related to law, or is that argument being made for the first time to us?
There is no place to argue it. In other words, the way this case came about is we went in front of the administrative law judge. The administrative law judge came up with his proposed recommended order. We took no exceptions. The director of the division signed the proposed recommended order as is, and we're here. We argued in our proposed recommended orders, which are part of the records, that none of this should come in and it was inherently untrustworthy. And can I tell you all the things that were wrong with the documents, or because
You've got 2 minutes.
Tell you what, I'll take my 2 minutes because I'm sure my opponent's going to get into it. But basically, I'm going to use 30 seconds. The logs are incorrect. The blood and the urine can't be taken at the same time. The witness testifies to that. The logs are incorrect when the time the urine's taken. The witness testifies that you can't have basically the blood and the urine being taken from the horse at the same time when the horse is leaving the enclosure, and these are all in different logs. She testifies that every single log is wrong for all 21
How
horses.
is that, how are those legal issues as opposed to factual issues, whether all this was done? And that goes back to the question, you seem to be saying that we don't need to file written exceptions if they're questions of law, only if they're questions of fact. Well, you're talking about questions of fact here, aren't you?
No, I'm talking about issues of law
As
that
to
the
whether-
judge determines that the evidence as a whole is untrustworthy, and that this judge abused his discretion by not determining the evidence as a whole was untrustworthy, therefore it doesn't come in under the exception. And I'll save my last minute.
Okay.
Thank you.
May it please the court, my name is Gar Chisenhall, and I'm here on behalf of the Division of Parimutuel Wagering. Just real quickly, I'd like to draw the court's attention to Rule 61D-6.005, which establishes the procedures by which race animals are tested for illegal substances. And subsection 3, Your Honor, talks about how the owner, trainer of record, groom, or other authorized person has to be present when blood, urine samples are taken. It also says that after urine is sealed as container and assigned a number, then a number information sheet is detached and slapped on a container, and or the sample tag, excuse me, is attached and signed by the owner, groom, or authorized person. And the authorized person stays in the detention barn with the racing animal until the animal leaves. So while the rule doesn't come out and say it, it's pretty clear that the purpose behind having the representative there is to make sure that everything is done correctly when the urine sample is being taken. Your Honor, I wanted to address your question about procedure. The administrative law judge issued a recommended order, and the very last page it says each party has 15 days or so to file exceptions to the recommended order. And then, that came after each side issued proposed recommended orders. So you have the PRO's recommended order, then you've got 15 days to file exceptions, and neither party filed exceptions, so then the division issued a final order. And this exception issue came up for the first time when I raised it in the answer brief. So the reply brief was the first time that the appellant was made aware of this error. But rather than being one issue here, I think there's really two issues in this case. First one, of course, is whether or not the exhibits were properly admitted evidence under the hearsay exceptions that we discussed so far. The other concern is whether or not Mr. Shaw has preserved that first issue for appellate review. Now, as I will explain, Mr. Shaw neglected to preserve that issue for appellate review because he did not file exceptions to the administrative law judge's recommended order. But even if he had filed the necessary exceptions, the court should still affirm the final order because the exhibits were trustworthy and Ms. Neer was qualified to authenticate the exhibits and to lay the foundation for their admission.
What makes her qualified?
Your Honor, first of all, if you look at the ALJ's recommended order, in paragraph number 25, he found that she has been an investigator for over 20 years. He also found that in the course of discharging her duties, she has witnessed the sample collection process that was done at this particular racetrack. Now, yes, not for these 3 race horses, but she has been there before when other horses were sampled. Also, I would take issue with the appellant's contention that she's not in the same business. And I think it depends on how you define what the business is. I think it should be defined as the business of determining if a urine sample is tested positive. Now, the samples are sent to University of Florida Racing Laboratory, and when they're sent to the laboratory, there's no way for anyone to know which horses came from or which trainer the horse belongs to. And that makes sense because you don't want someone at the racing laboratory being biased or anything like that. So it's kind of like a blind test. But once they identify a positive sample, they send the number attached to that sample to the division's office in Fort Lauderdale, and that's where Ms. Neer works. And in that office, they have stored the information part of the urine specimen cards. So when Ms. Neer receives the numbers that tested positive, she goes to a locker or a cabinet or something and identifies and matches up the number from the racing laboratory with the urine specimen cards. And then so in a way, she is part of the entire process. And you could also think of her perhaps as at least a custodian for some of the records, being the urine sample cards. And those are 3 of the exhibits that are issued in this case.
Were these documents admitted as business records or public records?
They were admitted as both, Your Honor. Now, with regard to the preservation issue, the division would submit that there's no need for the court to address the merits of the appellant's hearsay arguments because, again, he didn't preserve the issue for appellate review. And, of course, the appellant says that there was no need for him to file exceptions in order to preserve this issue. However, Mr. Shaw is overlooking the fact that all the cases on this issue have held that if a party has a problem with something done by an administrative law judge, then that party needs to file exceptions to the recommended order. And that rule makes sense when you think about the fact that in the administrative context, the agency which issues the final order is a lower tribunal. As the court is well aware, the primary purpose for the preservation requirement is to alert the lower tribunal of an error and give the tribunal a chance to correct that error. So if an administrative law judge makes an erroneous finding of fact or an erroneous conclusion of law in his or her recommended order, the aggrieved party files exceptions to the recommended order, and that alerts the agency which issues the final order of this alleged error and gives the agency a chance to correct it if in fact it is an error. Now, this argument also overlooks the fact that Chapter 120 of Florida statutes applies specifically to administrative law cases such as this. And Section 120.571L gives agencies such as division the authority to reject an administrative law judge's findings of fact if they are not supported by competent substantial evidence. As a result, the third DCA held in the case of NW versus Department of Children and Families at 981 Southern 2nd 599, that while the department could not reweigh the evidence presented to the administrative law judge, the department was allowed to determine whether the evidence was competent and substantial to support the LJ's decision. So, the question then turns to, well, what does it mean of competent substantial evidence? And in the Lonergan case at 669 Southern 2nd 1062, this court explained what that term means. And the key part of the definition is the part where this court said that competency of evidence refers to its admissibility under legal rules of evidence. So, under this court's definition of competent substantial evidence and the authority given to division under 120.571L, it definitely was incumbent upon Mr. Shaw to file exceptions to the recommended order and apprise the division of this error that the LJ supposedly committed by allowing the exhibits and evidence. Now, another point I'd like to address is the trustworthiness of the exhibits. Mr. Shaw takes issue with how some notations were made. For example, the daily record of sample collections show that the blood and urine samples were taken at the exact same time, and the security logs show that the horses left the state detention barn at the same time that the blood and urine samples were taken. Now, in light of the fact that all the notations may not have been perfectly made, Mr. Shaw says that it's easy to surmise that perhaps the urine samples were mislabeled and that the positive test results came from horses other than his own. But first of all, I'd like to remind the court that this is an evidentiary issue, and as a result, it's reviewed for a clear abuse of discretion. Secondly, I would like to remind the court that Mr. Shaw is not arguing, or he's arguing that the urine samples that tested positive for fentanyl did not come from his horses. So for the purposes of this case, the key part of the sample collection process is not the filling out of the security logs and the daily record sample collections. The key part is when the urine specimen is collected, when the specimen is sealed in its container and assigned an official sample number, And when that, when the sample number is affixed to the container, and when the numbered portion of the urine specimen card is detached and stored at the detention barn for later transport to the division office for Lauderdale.
And you're saying that the testimony was that Ms. Niera was directly involved in that process, because if the report came back from the lab that there was a positive test result, she was the one that went and retrieved it, matched the numbers, and did all of that?
That's correct, Your Honor. So she is part of the business, but it depends on how you define the business. Mr. Shaw has defined the business very narrowly in terms of working in the state detention barn, but I think it's fair to define it as being in the business of identifying a positive test result. Now, so the process that we really should be focused on is the process of, getting the sample, labeling it, and, and then I've left this out, but the trainer's representative has to sign the information portion of the urine specimen card. And
he says that the opposing counsel says, if I understood, now if I misunderstood, you'll correct me, but I thought I understood him to say that the reason that person is there, I call him a representative of the horse or the horse's owner, or you can call him a groom or whatever the technical term is because he's the one or she's the one has to escort the horse in, and that's it.
Well, Your Honor, if you look at...
And I thought, well, that person is there to make sure that, if there are any irregularities in taking the samples or whatever, that person would be there, would be able to voice an objection. And when they sign the card, that's what they're signing, saying that I was there and I was present when all that was done.
Well, Your Honor, you're exactly right. If you look at the text of Rule 61D-6.005, particularly subsection 3 of that rule, it's pretty clear why the trainer, the owner, or the authorized representative needs to be there. They're there to witness the whole sample collection process. And yeah, I'll grant you that on the urine specimen card, there's no attestation statement, but the representative does have to sign it. And since the representative is present during the whole process, when the urine is collected, when it's sealed, and when the specimen card is signed, you would think that if some kind of error was made during that key part of the sample collection process, then Mr. Shaw would have called one of those representatives as a witness during the hearing to cast doubt on the credibility of that very key exhibit. But he didn't, and because of that, I don't think you can come close to saying that the administrative law judge clearly abused discretion by letting exhibits come into evidence. The final point I'd like to make is, or to address, is Mr. Shaw's argument that Ms. Niera was not a qualified witness. I think the main point of his argument, we've already talked about what he says in reply brief about how she's supposedly not in the same business, but the initial brief was directed more towards the fact that she was not personally present when these samples were taken. And the law is pretty clear that the witness does not have to be there, or the witness does not have personal knowledge of these exact exhibits. For example, Professor Earhart explained on page 1033 of his treatise on Florida evidence that records of a regularly conducted business activity and public records and reports are authenticated by a testimony of a witness that the records are genuine. The witness need not have actually prepared the records because familiarity with the records and the way they are kept is sufficient to authenticate or identify them. And with regard to establishing the foundation under the hearsay exceptions, the first TCA explained in the Forrester case that with regard to the business record exception, it is not necessary to call a person who actually prepared a document. The records custodian or any qualified witness who has the necessary knowledge to testify as to how the record was made can lay the necessary foundation. And then, as for who amounts to a qualified witness, Professor Earhart explained on page 885 of his treatise that any witness who has the knowledge of the business to testify to the method by which a particular record was entered is a qualified witness. So in other words, this witness just sees general knowledge of how the records were made and does not need to have made the records herself. And again, just to repeat what I said earlier, in paragraph number 25 of his recommended order, the ALJ found that Ms. Neer has been investigated for over 20 years. He also found, and she testified to this in transcript, that she has witnessed the sample collection process at the Calder racetrack in the past. And again, she's part of the whole positive sample identification process, because when a positive test result comes from the racing laboratory, she takes those numbers and matches them to the urine specimen cards, and she's the one who finds out first, exactly which horses tested positive. So when you take all this into account, Your Honors, the ALJ clearly acted well within discretion by laying the exhibits into evidence. And in conclusion, the division would submit that there's no need for the court to address the merits of this argument because it is unpreserved. But even if the court thinks that it is preserved, the final word should still be affirmed because the exhibits were trustworthy and Ms. Neer was a qualified witness. And if the court doesn't have any questions, I'll surrender the rest of my time. Thank you very much.
Thank you, counsel.
May it please the court, I have about 52 seconds, so I'm going to quickly read what I promised I was going to try to read before. And I would ask the court in reviewing this, the significant issue to me is the untrustworthiness part of both the exceptions. And I'm going to just read a couple of excerpts. This is from page 92 of the transcript. Question, so somehow we have tests supposedly taken at the same time that they shouldn't have been taken because the horse was already on the way out of the barn. Answer, yes. That is for both of the samples that we have gone over. Do you think that's going to change for the third one? Answer, probably not. Question, why do you say that, ma'am? Answer, based on the information on the first two. Okay. Question, and all of the information on those are inconsistent with what you have testified that the rules are supposed to be, correct? Answer, yes. Page 94, so these logs indicate that the facts that they are contained therein couldn't have happened the way they say, correct? Answer, correct. Page 95, question, but now as we further look at these logs, you realize that there are all kinds of problems with the dates and the times, correct? Answer, yes. People are not doing what they are supposed to do, correct? Answer, yes. People are making mistakes all over the place, correct? Answer, yes.
So that was all heard by the fact finder and basically rejected, right? I mean, the fact finder in this particular case heard all of that and said that, well, I do think that, number one, she was qualified to get the records in, and number two, they were trustworthy.
And that's the abuse of discretion on that issue.
All right.
Thank you, Your Honor.
Thank you, counsel.